All right, good afternoon, everyone. It is 12 o'clock on the nose, which for those of you who know me means that we're late. I'm Brian Leland. I have the distinct pleasure of being the director of the Fairbanks Center for Medical Ethics and directing our Clinical Ethics Fellowship program. It's my pleasure to welcome you to our 2022-2023 September FCME lecture series lecture. Want to draw your attention to some upcoming events, in particular the one on October 5th. I hear that guy gives a great lecture. I also want to thank everyone for their ongoing patience regarding our transition to the new CME and CE process. As a friendly reminder, maybe, okay, we'll try this. Here we go. You can text 74086 now or up to 102 hours after the end of this lecture to get your CE or CME credit. So please take an opportunity to do that. And if you haven't already, just program the CME number as like a favorite or a contact, and then you can pull it up whenever you do for this or for other activities. You will get your certificate sometime in the next 2 weeks, but your credit gets logged as soon as you put this code in. I also want to take a quick opportunity to introduce to everyone, both with us today and online, our new group of ethics fellows. We started the Ethics Fellowship up again this year, August 24th, and we have 8 fellows with us this year that I am very excited to announce. So when I say your name, I'll just invite you to maybe just stand up and acknowledge yourself. Starting with Dr. Nomi Sherwin, who's an adolescent medicine fellow here at the IU School of Medicine. Bridget Swartwood, a PhD candidate in the Department of Medical Humanities at IUPUI. Joel Cox, a middle school teacher at Crystal House Academy South. May the force be with you. Dr. Emily Holmes, assistant professor of psychiatry here with IU School of Medicine and IU Health. Rachel Miller, our patient relations consultant for IU Health Saxony and IU Health North. Kirsten Oswald, who's project manager for the system quality and patient safety for IU Health. Rebecca West, our nursing professional development practitioner, who directs the, I think it's called Transition to Practice course. And then Eric Williams, staff chaplain here at our very own Methodist Hospital in the intensive care unit and our emergency department. So we're ecstatic that they're with us. And by all means, grab one of them after this session and set up a time to talk with them about their fellowship experience and whether it might be right for you. All right, let's talk about today's lecture really quickly. As a reminder, this webinar is going to be recorded, and then it will be posted on our website, which is fairbankscenter.org, and that will be within the next week or so. And we invite you to send your colleagues or friends that information as well, if that's something they might be interested in viewing. If you are watching via Zoom, please take note of the Q&A box that allows you to post questions, but note that it is most likely that we'll reference those at the end of the session rather than in the middle of it, just to allow the presenter to streamline their presentation. I will now be happy to introduce our speaker, who I must note does not have any financial conflicts of interest, but Ms. Robyn Axel-Adams is a dear friend and colleague of mine here at FCME. She manages the center. Before she became manager of FCME, she worked as a staff chaplain at IU Health Ball Memorial Hospital, did that for about 7 years, and then was also with the Palliative Care team for about a year. She is an ordained United Methodist clergy person and a Board Certified Chaplain. Her Masters of Divinity is from Emory University, and her Masters of Science and Leadership is from the University of Evansville, which is where my mother grew up, so we are bonded. And then she completed the FCME Fellowship with the 2011-2012 class. And she focused at that time on developing curricula for teaching internal medicine residents about medicine and spirituality. Currently, she co-leads the School of Medicine's Religion, Spirituality, and Medicine concentration. She is in the process of working on a proof of concept for having a dedicated advanced care planning conversation in outpatient clinic settings. And I'm excited for what she tells us about today to be informing some of that work moving forward. She is married, has 2 children, and only 2 cats currently. I thought, okay. She is a self-proclaimed NPR geek and a fierce LGBTQ ally. I'm excited to welcome her to the stage to present to us. Her presentation title is Things Are Changing, Indiana Advance Directive Law Updates. Please welcome Robyn Axel-Adams.
Thank you, Brian. Let me see if I can, okay. There's our accreditation statement, our disclosure statement, things that we have to show to you all. All right, so here we are. So I'm coming at you today from the hospital perspective, because there are so many things about this, this law that will affect and impact all of our healthcare within the state of Indiana. There's a lot of weeds that are really in this law. And what we're going to do is look at this from the lens, like I said, of the hospital perspective. And I know each one of you also comes with a different lens. We have chaplains in the room, social workers in the rooms, online. I know we have physicians. Everybody looks and needs the advanced care directives in a little bit different way. So I'm going to hopefully give you as much of the big picture as I can, and then we'll leave some time for questions at the end as you kind of need to get into the weeds as you interact with them. So here are our learning objectives, because we always have to have learning objectives. So the grand question is, why did the state of Indiana, why did our legislation make all of these changes? This is actually the first comprehensive update to the Indiana Advance Directive statute in almost 30 years. The old advanced directive laws were spread across 3 different statutes, and these statutes had vague and conflicting language. It was also really outdated language. Any of you who had to live through working out a living will knows that sometimes even that language is unhelpful, and especially in the clinic setting. There were multiple methods to appoint a legal representative. We had both a healthcare representative and a healthcare power of attorney. Those differences were often poorly understood and often confusing. And then COVID-19 really presented a challenge around the language of in the presence of. And Indiana was really behind and out of step with the rest of the country. And so there was a group of people that worked really, really hard to help the Indiana legislation see through their way to pass the Senate Enrolled Act of Act 204, which was passed in 2001. So this has actually been law for a little over a year and a half now. But they slowly allowed us to make this kind of finalized. The state gave Indiana some grace. So all changes, like I said, are in effect now. They were as of July 1st of 2021. But the biggest changes are the signature changes, and I'm going to dive into that, I promise, but that must happen as of January 1st of 2023. So all the changes that I'm going to talk about must occur and move forward after January 1st of 23. However, there's going to be a time period where we're going to be in this gray zone. That's why I have this gray splotch up here, because all old forms are going to be grandfathered in. So do you have to create, do patients have to create a new form when they come into the hospital? No. And yet, what a great opportunity for you to double check that this is what they still want, and this is who their decisions that they might want, and who they still might want to make plans for them. I was looking at advanced directive yesterday that was signed in 2015. So I don't even know if their healthcare representative is alive or not, but so it's a great opportunity to update those advanced directives. All right, so let's dive into these new changes. So the biggest change is that every advanced directive must be signed by a declarant. So the declarant is a really fancy word for the person or the patient, or a representative, so it can also be signed by a representative, and 2 witnesses or 1 notary. The witness cannot be the named healthcare representative. So if you have a form and you've named a healthcare representative, one of those witnesses cannot be the healthcare representative, and only 1 witness can be a family member. So if you are in the room with someone and you are one of the witnesses, then 1 family member can, but you cannot have more than 1 family member. We're going to delve a little bit more into this later about how people can sign the form, but the biggest piece that's important to remember is that it has to be the patient themselves, the declarant or a representative, and 2 witnesses. That is the biggest thing that will change as of January 1st. If they don't have those 2 witnesses' signatures on them after January 1st, then unfortunately they're not valid. So The other change is that there is no set form that a person has to use now to share their values and preferences. The state of Indiana has said they are not going to create a form. And so you can use guides that are already created. The Conversation Project is one of my absolute favorite guides. Prepare for Your Care has created a guide just specific for Indiana. So if you go to their website, you can look for Indiana. I know many people at University Hospital love 5 wishes. And so you can now use 5 wishes, and it's a legal document as long as it has 2 signatures and the patient's signature. You can also write your own. So I did that this morning, and I put example on there because this is now a legal document because my 2 friends have signed it for me, but hopefully with the word example. But I also think these are the advanced directives that I would probably live with. Try to help the person that you're writing be as specific as you can without tying someone in too much. So try to make it a little bit more helpful than the living will, but not so tight that the providers don't have any wiggle room on it. And this actually came up, we've actually had an ethics consult a couple of weeks ago from one of our system hospitals that one of the chaplains called me and said, hey, somebody wants some really specific stuff in their healthcare rep or their document. How do I do this? I'm like, grab a piece of paper and help them write it out. And then just make sure it has 2 witnesses and the patient. So you can see that this here is a legal form, even though it doesn't look like a legal form. It's on a piece of paper with my signature and 2 witnesses. Here's another really big change. Verbal advance directives are also legal. They have to be made to the healthcare provider in the direct physical presence of. So we talked to legal about this because we didn't really have, there's no guidance in what needs to be documented in the legislation. So I asked IU Health Legal, and they said, please document who was in the room, when it happened, and provide as much detail as possible. So if a person says to you, if all of you providers who are out there, if someone says to you, I want my sister Joe to be my healthcare representative, or I don't ever want to be trached and pegged, all of those things, if you can document it, are advanced directives that are legal, as well as revoking the advanced directive. That is also legal as done orally in the direct presence of a healthcare provider. So all you healthcare providers are like, oh, where do I document this? Because it doesn't really help, honestly, if you document it in your notes and it's buried. That does absolutely no good to those of us who are looking for these advanced directives. So in Cerner, under Power Notes, if you've seen those advanced directive tabs, they are you can free text in them. So there's 2 ways that you can do it. You can either use the equals and just start typing out goals of care. And the Palliative Care team with a lot of other people have developed a really great template. So you can use that template, or if you simply want to free text, you can, but again, that Power Note and advanced directives, you can free text in there. It's not just the only place for the scanned documents. And so I would recommend that you have your subject line just be verbal advanced directive. That helps us know that there is that advanced directive there. Instead of, if you bury it in your notes, we're never going to be able to find it. Another change is that we now just have the healthcare representative. The healthcare power of attorney is going to disappear or has disappeared. So the role of the healthcare representative and the role of the healthcare POA, if you understood the difference between them, those differences have now disappeared. And all of the powers and authority that the healthcare power of attorney and healthcare representative have come together. And so that means that the healthcare representative does continue after death. That was one of the large ones is when it ended. And just as a reminder, this is not covering a financial POA. You'll still need to make sure that the people have a financial POA, but there is no longer a healthcare POA as of January 1st. Again, if they sign a healthcare POA today, it's going to be a legal document. But if January 1st, 2023, if someone walks in with a healthcare POA, then we'll need to contact ethics and legal because there's some challenges out there with that. All right, so another change that is happening in this is, and this is not so much of a change, but there's some nuances to it. You've always been able to name more than one healthcare representative, but there are so many nuances now with naming more than one healthcare representative. Honestly, when I have read them over and over and over again, it makes my head spin and it's confusing. But and in Indiana, we're going to also go through the form in a little bit that we have created. We have tried to make it as easy as possible with the form that we've worked on for the hospitals in Indiana. But I will say that the legal teams and the legal community have done a really great job of educating each other. And so I've already had an ethics consult where someone had pulled language that's right out of the legislation. So you may see language that you're not familiar with. So I'm telling you about some of these things, not because probably you will create a healthcare representative form that does this, but you might read one. So you can order them, and I'll show you the form in a little bit. We're going to go that in a little bit, but you can say who you want to be your first healthcare representative and who you want to be your second healthcare representative if the first person is not available. You can say that you want both of them to have equal and independent authority. And that's what we ran into in the ethics consult that we got. If there is the language that says that they have equal and independent authority, that means that you do not have to double consent. You find the person that is reasonably available and you're able to consent with them. So you do not have to make sure both parties or both healthcare representatives sign the forms. You should keep them both informed. The challenge is that this particular family was a challenging family. And so you would keep both healthcare representatives informed just as you would any challenging family. And it's okay to just name more than one. You can do that. You don't have to. And if you name more than one, then they do have equal authority. And so it gets a little bit stickier, but it's similar to what the proxy decisions are, that then it would sort of be the majority wins. And you can also just name one. Again, there are lots and lots of weeds, and I'm just warning you about these in case you see any of these that have been written by attorneys in the community. There is a lot of leeway about naming more than one healthcare representative. So when you name someone as a healthcare representative, what responsibilities are they taking on now? So it specifically states in legislation that they need to take into account the intentions, the preferences, and the values of the patient. They have to consider what the patient would want. They then have to act in the best interest of the patient if the preferences are not known. They have to be reasonably available. And reasonably available really does mean that you are able to contact without undue effort. That's what the legislation says. Able to contact without undue effort. And then they have to act in a timely manner, considering the urgency of the need or the decision. And so if you have a healthcare representative that you can't find and you need an urgent decision, then you go on to the next healthcare representative. And if there is no next healthcare representative, then you go to the proxy list. So this is all set out. So I know our social workers are amazing at finding people, but if you are not able to find someone in a timely manner, there are processes and steps to be able to go through with who to go to next. So what authority do they have? Along with responsibility does come authority. They are allowed to provide consent, of course. They have to be provided access to appropriate healthcare information of the patient, and they can also apply for benefits on behalf of the patient. So what happens if a healthcare representative, a named healthcare representative, doesn't want to be the healthcare representative anymore? We had an ethics consult about this recently. And so what happens if the healthcare representative doesn't want to be? Then they have to inform the patient if the patient is alert. They have to inform the provider. And then if a lawyer created it, they're supposed to inform the lawyer. I put that in there, that's because that's what the legislation says. We know the practicality of that in the hospital setting, that you don't have to wait until they've informed the lawyer, as long as they've informed you. And then the named healthcare representative can delegate this to someone else who they would like to make the decisions in their stead, unless the Advance Directive explicitly says that they can't. I told you there are so many weeds. So but if you're going to delegate it, that delegation needs to be in writing or verbally to a provider. And if you don't want to delegate, if they are like, I am done and I'm walking away from this, then it goes to the proxy list. So if a healthcare representative is allowed to delegate, and if they do not want to, it goes to the proxy. What if you, as a provider, are asked to do something that you are not wanting to comply with by the healthcare representative? Legislation lays this out too, that you are to inform the healthcare representative that you are not going to comply with what they would like. Then you have to transfer the patient to another provider. You will see that this language mirrors a lot about what our dispute resolution process looks like. And if the transfer is unadvisable, then follow your own dispute resolution process. So I want to just inform you that it does have, there is language in there about not if the provider does not wish to comply. So another change is that all other states' forms are okay. So if you have a POA from another state, you can now accept that. That was not always the case in Indiana, but now it is. So if you have any advance directive that's from another state, they are okay and great for you to use. All right, so here's now where you need to take a breath and know that it's going to be okay. And I'm going to explain this as best as I can. And again, what I'm about to explain is more in case you see it, not because I anticipate that you will live this out. How do we sign the document? There are now 5 different ways that you can sign an advance directive. The first is the declarant, again, fancy word for the patient or the adult, and 2 witnesses or the notary sign on a piece of paper. That is what 99% of what you all are going to be doing in the hospital setting. The declarant and 2 witnesses or the notary can also sign electronically. I would love for this to happen within IU Health, and this is something I'm going to continue beating the drum about, is so if there's ways that we can sign this electronically. It does now help that we have the form, and so we can hopefully get people in the process of doing this. But it can be signed electronically. So if you ever see something with an electronic signature, it's legal. You can now sign electronically during a video call. So if you are not in the presence of each other, but you're on Zoom together and you all can sign electronically and email it like you do the DocuSigns, you can do that. This is the one that always makes me smile. So you can also sign with the exact same paper copy forms during a video call. And number 5 is really just a telephone call with the same ideas. So you all are in different locations. And remember, this was written during the time of COVID, and we really had to have flexibility for what would happen if people cannot be physically in the same space. All of you will have the exact same form in front of you. You would fill out, Robyn Axel-Adams names, Brian Leland as her healthcare representative. All of you have the same paper. You each sign the same looking paper, and then they get compiled back together. Immediately, they are legal. And then they do have to be brought together within 10 business days and then stamped on there when they were received and then compiled. So you could have a healthcare representative form or any advance directive that is 8 to 20 pages long because of having all of these different documents. So it's okay. If you need help navigating it, we're here to help. And then the other part is if it's signed during a phone call, the witnesses have to be able to confirm that it's the patient's voice. And so hopefully you know the patient's voice, or you can ask some of those identifying informations to know that this is actually the patient. So again, this is not something that we will potentially do here. I will also say that if we have another case where we are not allowed to be in the presence of each other, these options are available to us and to anyone. So just know that if you see one of those that comes through, then they might look funny, but they are legal. And I guarantee you, even though I say today, oh, you probably will never see one of these, next week we will see one of these. Another thing that is in legislation is that the healthcare provider who acts in good faith on an advance directive is protected. And so the providers are protected by following any advance directive that they believe is a true and valid advance directive. So those are the major changes. I now want to take a little bit of time to look specifically at the form that has been created. Those of you who are present in the room have a copy of this form online. I will tell you how you can get it. But multiple groups, especially the Indiana Patient Safety Coalition, really worked to create this form because the state of Indiana says we're not going to create a form for you. And so there was an interdisciplinary team that I was a part of. Amy Martin, our Vice President of Clinical and Organizational Ethics, was a part of. Palliative care doctors, advanced care directors, lawyers, so many different people were a part of this team that created this form. And then it has been taken to the Indiana Patient Preferences Coalition to approve it. So our hope is that many of the hospitals in Indiana will approve this form so that we will have a consistent form for us all as we navigate patients moving from hospital to hospital. I'm going to walk through this form in a variety of steps. But the first that we're going to look at is how to name that, that healthcare representative. And so you'll see here that there is the chance that for the declarant, again, that fancy name, to put their name and their date of birth. And then for you in an order to put who is the first person and who's the backup person. And I know that not everybody's thrilled about the fact that we have already ordered them instead of just leaving it for there to be more than one. But if there is more than one that's not ordered, you have to just have very specific language in the legislation, or I mean, in the piece of paper. We worked super hard to make this just a front and back piece of paper. And if we included every nuance that we had to, this form would be 30 pages long, and that's not helpful to anyone. So you will be able to name a healthcare representative who is first, and then you will be able to name the backup healthcare representative. On the back side is where you can sign the form. Now the signature can be anything that is even an X, so it does not have to be a legible signature, as long as there is a mark by the patient. Now I did share earlier that a representative can sign on behalf of the patient. And so if that is the case, if I am truly not able to sign, but I'm able to indicate that I want someone to be my healthcare representative, but I cannot sign. For example, I'm working with ALS patients right now, and many of them have lost the ability to sign the pieces of paper. And so you can have a representative sign for them. So in the signature line, you would just put your name, you would sign it, and then you would, after the word declarant, you would make sure that you write the word representative. That is one area that I've noticed that we kind of dropped and that we forgot about. We had that in one ideation, but it did not make it in the final one, but that's okay. We'll all work with it. And then you would print your name and again, the declarant. And I don't think I screenshotted this well. At the very, very top, the patient's name is to be printed at the very top. That way their name, just like the post form, is on both sides. So that if a representative signs for them, the patient's name is still up at the top. And then there you have your opportunity for your two witnesses. So the witnesses would be on the left, and then the notary could be on the right. Another piece that was added that's a little bit different to other healthcare representative forms is that we did add an optional statement of preferences. This language mirrors language that is in the Illinois healthcare representative form. Instead of creating our own, we were able to borrow good and hard work language. It really does talk about the quality versus the quality and quantity of life. This is not so prescriptive that there is not ability to, that if a person were to say that they want to stay alive is more important to me. I hope that you will see that the language says that I want my life to be prolonged to the greatest extent possible in accordance with reasonable medical standards. And so there is a lot of ability for a healthcare representative to still see that the fact that that the reasonable medical standards are saying that what we're doing is potentially inappropriate, and so we're going to move away from being from staying more aggressive measures. But the patient can also indicate that they do not want to complete this section at this time. Any of those three options are perfectly fine with our new form. The most important thing and our ultimate goal whenever we fill out any advance directive is to really then make sure that we have goal concurrent care. The reason we fill out advance directives is to really indicate what the patient wants, what matters most to our patients at the end of their life. And so once the patient has been able to fill out these forms, then our hope is that when they get to the point that it is the end of their life, that we are able to provide medical recommendations that match and are concurrent with the care that they want. There are a lot of changes that have happened within the legislation that I've gone over. And so we have created a quick reference guide. For those of you that are in person, you have that in your hands. For those that are online, I am working really hard to get this form and to get our healthcare representative form on our team portal. It is a little slower than I would like it to be, and so it is not on the team portal yet. And so if many of the team leads have this form already, if your team lead, if you need a form and you do not have it yet, please shoot FCME an email and we will be happy to get out to you, as well as this quick reference guide, because we want to be able to help provide you all with as much information as you can. The other thing that's really important is how do we educate patients about advance directives and about advanced care planning? These all have been about advanced directives, but advanced care planning is actually so much more important. I listened to a lecture a couple of weeks ago about these new law changes, and I so appreciated how she phrased the idea of that advanced directives are the what, but advanced care planning really is the why. These documents are as good as the piece of paper they're written on until the person has had conversations with their healthcare representatives. And so we need to educate our patients about having those conversations. We need to be bold and have conversations with our patients as well. So how do we educate patients about advanced care planning and about advanced directives? If you have this downloaded somewhere, many of you know exactly what this is. It's a 13-page document that the state of Indiana has created in 1999, and they revised it in 2013. They have pulled it off their website. Do not give this to patients anymore, please, I beg of you, because this is out of date, especially in light of the new laws. And so you cannot find it on the website anymore, but many people have downloaded it. So if you have, please throw it in your trash box because it is not valid anymore. But what we did do is that I worked with an interdisciplinary team to create this brochure about advanced care planning. You can currently find this on the Brand Center. It has been published on the Brand Center. When you go to the Brand Center, please look up advanced care planning, not advanced directives, because there's a different brochure that it's also out of date. But you can find this, and I know we also had this for those of you who came in. But this, I hope, is going to be a helpful document as you talk to your patients about what advanced care planning is. And again, just encourage those conversations. These are some really great questions to ask as you think about how to help patients think through what their values and their preferences are. Because I guarantee you, if you look at a patient and say, hey, tell me what your values are in healthcare, they will look back at you like you have three heads. And so you can ask these types of questions. And when you ask these questions, that really helps you get a picture of who they are and what they might want towards the end of their life, so that when a provider approaches them, they can say, you know, your mom shared with me that it was so important for her to be totally active and to be able to do all these things she wanted to do. And if we do this with her, then she won't be able to be active anymore. So we are going to recommend that we do X instead of Y. Again, that's that goal concurrent care, that we know what the patient's goals and values are so that we can provide care that matches that. So these are great questions to help elicit what the patient's goals and values might be. All right, let's for a minute look at things that did not change in the law. And I need to thank Susan Hickman, who created this beautiful tree here. But things that did not change in the law. So if no healthcare representative is named, this is the order, and you heard me use the word that you probably weren't used to hearing me use, but it's the word proxy. These are now called proxies. They used to be called default surrogate decision makers, but this legislation now calls them proxies. And so this is the order that the proxy list goes in. This applies to minors as well, but just remember, oh, my mouse is not working. Okay, just remember that the minors starts at parent. So this proxy list also applies to minors because all minors are not able to make their own decisions. We do have people that are not able to serve. So you're not able to serve, this has not changed. If you're legally separated, if there is a protective order against you, or if the individual who is subject to a pending criminal charge in which the patient is the alleged victim. So if in the adult hospital, if you're just really unsure about whether a particular person should be making a decision because you've heard that there might be charges coming, please just consult legal and they can help walk you through this. I've already talked to them about this. They know this, there's the heads up about it. If you are at Riley and you're not sure whether a particular person should be making a decision, please reach out to Jennifer Gerard or your risk consultant, Corey Chambers, and they'll be able to help navigate whether a person is able to make a decision. But so this has not changed. Everything that I'm just telling you here is the same as it was before, but it is now codified in the same law. Other items that did not change. The most recently signed advance directive is the advance directive that is in effect. So if someone comes in, if 3 siblings come in with 3 different advance directives that are dated on 3 different days, then the one that was signed the most recently is the one that you need to go by. And again, and I know this should be a duh, but I just need to say it, that the advance directive only goes into effect when a patient loses capacity. And our goal is always to try to help them gain that capacity back so they're able to make the decisions for themselves. So there are a few other pieces that were addressed in the legislation that are not technically advanced directives, but I know that we deal with them a lot here. So I just wanted to run by them really quickly. The post form. This is just a reminder. So nothing changed about the post form. This is still a physician's order. There is no reason to turn and ask the family if a patient comes in as a DNR. There is no reason to turn to the family and ask if you want them to be a DNR, because this is a physician's order. So you still will work with the post form. Nothing has changed there. Nothing has changed about the fact that only an appointed healthcare representative can sign or change a post form. And if you're not really sure what a post form is, like you have no clue what I'm talking about, or you'd like more information, this website, indianapost.org, is a really great website, which will be able to provide you with more information. And you will probably see some friendly faces on that website that are helping to educate you. The one change that did happen with the out-of-hospital DNR is that the PAs and NPs can now sign an out-of-hospital DNR. That was inadvertently left off in the last legislation. That when they talked about when they had legislation around a DNR, so that was corrected in this one. So that is one thing that has changed, that the physician's assistants and NPs can now sign the out-of-hospital DNR. All right, I've tried really hard, and I think I succeeded in leaving a lot of time. And I know that there might be questions specific to what your field is. And so please feel free to ask those questions. We have someone who's looking at the Q&As. Annie's giving me a look, which means there's probably a lot of questions already in the queue. Here's my information. And like I said, if you need any of these forms, don't hesitate to reach out to fcme@iuhealth.org. Sure.
Okay, I know we have.
Hold on, before I go, is Katrina here? Okay, so I have a phone a friend, and my phone a friend is my legal friend, Katrina Klingerman, and she and I have been working on this. So if there's going to be times, because I feel like I'm walking in a little hesitant water, because there's a combination of ethics and legal in this. And so there's going to be times that I'm like, Katrina, I don't. So my phone a friend is here, and I do not have a limit of how many times I can phone a friend.
Okay, before we get to people in person that have questions, we do have quite a list online already. I have a couple things I want to say. If you are listening online, we have a lot of questions that are anonymous, and I appreciate that you want to keep your anonymity. If we don't get to your question, please email fcme@iuhealth.org, the email address that's on the screen, so that we know who to get the answer to. And if you do have questions, please feel free to leave your name in here. Everybody has a lot of questions, so we appreciate this. And if the forms that Robyn was talking about, that you will receive a link with an evaluation tomorrow, please complete that evaluation and we can email you the forms. I appreciate that you could email, but we do not need 250 emails for the forms. So please complete the evaluation. Okay, I'm going to start with a couple online. And if you have a question in here, please raise your hand. Matt has another mic so that we can make sure that people online can hear you as well. I'm going to go in order, and some of these may have been answered as you were going through your presentation. So if it was, please just quickly readdress it. Thank you. All right. With the verbal advance directive, how is it confirmed if the declarant is cognitively competent to make that statement or decision?
Yeah. So the question, well, I'm sorry, you said it in the microphone, so I don't need to repeat it. So you would, the same way you would decide about anybody if it has capacity. You would do a capacity assessment, and you don't have to call psych in. Emily, you do not need to worry that you're going to get all these psych consults for signing a healthcare representative, because I'm correct, aren't I, Dr. Gifford, that Dr. Holmes, that anybody can do a capacity assessment. She's nodding ferociously. So do a capacity assessment, and if you feel that the patient has capacity, then they can verbally say that who they want to be their healthcare representative, or any of the other advanced directives.
Okay, I'm going to go to another one online, and then we'll check the audience. Does the HCR require a legal document?
Yeah, so it's the same sort of recommendation. It's the same sort of requirements. I mean, there is, so I could have just said on a piece of paper, I want Brian Leland and Annie Motz to be my healthcare representatives. And then Matt and Katrina could have signed it. My signature and 2 witnesses. That is like the golden key. If I want you to walk out with nothing else, the patient and 2 witnesses, but it does not have to have any particular form. Piece of paper works great. I actually, a colleague of mine who is up in Fort Wayne has done this presentation, and she has hers on a Post-it note. So it is a bit of a joke to say that it can be done on a Post-it note, but a Post-it note is a legal document as long as it has the patient's signature and 2 witnesses and dates. So if you see a Post-it note scanned into an EMR, as long as it has those signing requirements, it's legal.
Okay, we're gonna go in person.
Hey, Robyn.
Hey.
So as far as the timing of advanced directives, as far as the latest signed document being the most appropriate and the one to follow, how does that fall in line with the provider-led and driven conversation with the post form? If someone comes back and signs a healthcare representative form later and fills out that advanced, or the little advanced directive portion at the bottom,
Sure.
If you understand what I'm saying.
Yeah, so I think, let me make sure I've answered the question correctly. So they have completed a post form in January. And then in March, they fill out a form with the statement of preferences. Okay, and they contradict each other. Okay, because it's always fun to make things as complicated as we can. So there's a couple of things. So first of all, a physician's order, and I'm going to look at Katrina as I say this, but I've had this question before, but a physician's order will always trump. So great, I'm getting a nod. So it poses a physician's order. And if it trumps, then that maybe the patient is staying with their current preferences are, because we know that people's preferences change. And so I would say you should have a really good conversation with the patient and the healthcare representative to see, hey, why do you think that they changed? Let's talk about this. It's an opportunity for conversation. And again, the statement of values or the preferences are not locked in. They are the optional, they are preferences. So does that sort of clear that weed up a little bit? It does. It opens the door for a further conversation to say, hey, what has happened in the last 3 months that maybe made her ideas change?
A quick question. You said for the verbal consent or verbal advance directive with physicians, it had to be done in person in the presence of.
Yeah.
With the rise of virtual care, does that mean you cannot have or document verbal consent over a face-to-face virtual appointment, but you can have them like do the signing thing on the posted form or whatever else? How does that work with virtual
Yeah, I've
care?
really struggled with this. And Katrina, so the question was, now that we're doing more and more virtual care, how do we want to address the fact that the verbal, it says in presence of?
Yeah, I'm not 100% sure on that. I think it's one of the gray areas we're dealing with. But I'm also happy to look back at the language again and see if there's more clarity there that I'm just not remembering at the moment.
Yeah, so I think that there are what I have advised other providers to do that with the virtual care is that you can have the similar documents and bring them together. I always know that it's the idea of, is a patient actually going to be signing a document and mailing it in? So there is, I think, I wish I had a clear answer. I will say that when I have read this multiple times, it says in the presence of, and so I think that navigating what in the presence of will look like. So Katrina, I can give you, I was always looking at page numbers and I wrote page numbers down everywhere. Where is page 34 is probably what you want to head for.
Okay, I'm going to go back to a couple online here. And some of these I think will be answered pretty quick. Will any HCPOAs drafted before January 1st law change be grandfathered in under the new law?
They will be. All forms. The challenge is that they will be granted in under their right. So they will have the right of whatever it is when you signed the form. So the rights are going to be different. That's why I say we're going to be in a really gray area for a little while. So what a great opportunity for you to just update those forms.
and I believe you just answered this one as well. The verbal advance directive, it does not have to be a physician. It can be a healthcare provider, or it does have to be a physician.
The language says a provider.
Provider. Okay.
Oh, Katrina looks like she has a, oh, sorry.
Okay.
I heard a, ooh, so.
Okay. Can the proxy list delegate responsibility also?
Oh, thank you so much. I'm so glad you asked that question. I had that on my list to talk about and I forgot. Proxies cannot delegate. So if a proxy decision maker, we had this as an ethics council the last couple of weeks. If a proxy decision maker does not want to make a decision, they do not get to delegate. It just goes to the next person on the list. So that's the difference between the healthcare representative who is allowed to delegate and a proxy. So there are different rights and privileges that you have by being named a healthcare representative. Sometimes people will say to me, well, why, if it's going to be my husband anyway, why should I make a healthcare representative? And there are different rights and responsibilities that you get as a named healthcare representative than you do not get as a proxy. Eric.
Just double checking. You said that only an assigned healthcare representative can change a post.
That's correct.
Does that mean that a proxy cannot change a post?
That's correct.
Oh, well, that will make life interesting.
And the palliative care team has been working with that. I mean, that's something that the palliative care team has been doing and is aware of for years. So yeah, go for it, Katrina. I see.
Okay, so the statute defines presence as in person, via audiovisual where everyone can see each other, or via phone where everyone can hear and identify each other. So the verbal could be done in the same room as the provider, over a Zoom call with the provider. Any of those will work.
Thank you so much. I'm glad that I missed that you were here to answer that. So if you're doing telemedicine and you are a healthcare provider, you can take that oral advance directive. And I know that palliative care has really struggled with that, of how to mail those forms back and guarantee they'll get back. So this really does allow you to. So as long as they're visually able to see each other, that's what you're saying, Katrina. And you need to be able to, don't forget, you still have to have those two witnesses. So document, because Katrina was the one that helped me with this, document who else heard this, because you have to have the witnesses to be able to say, yes, I heard that mom said, or that Jane said that this was the case.
Yeah, it's not just visually. It says the ability to speak to each other through telephonic interaction, as long as you can identify each other on the phone call.
So does that help clear? Thank you so much for Katrina for looking that up super quick.
Okay, so there are quite a few questions all referring to provider.
Yeah, do you want to look at the definition?
Provider?
The definition of provider, I think, is on. It is defined in there.
So I will say there's also an attorney that has been helping kind of answer some questions in the Q&A, Jeff Dibble.
Yeah, so Jeff is one of,
Okay,
thank you, Jeff,
good.
for being online. Jeff is one of the attorneys that help write the legislation. And when Katrina can't answer it, he's my phone a friend. He's my second phone a friend. So thank you, Jeff, for answering some of the questions.
So his response to this says, any licensed healthcare provider defined in 1636-712 can be the bedside witness to a verbal AD or an oral revocation of an AD in the direct presence of a healthcare provider, such as a physician, PA, NP, APRN, etc. Does that help clarify provider?
So yeah, so here, as soon as she read off the legislation, so the legislation says healthcare provider, Katrina, this is on page 30. It says means any person licensed, certified, or authorized by law to administer healthcare in the ordinary course of business or practice of a profession. How's that professional legalese for you? Go for it. Thomas.
So I know you said that the latest signed advance directive takes precedence over other documents. What about in a situation where a verbal advance directive between the patient and maybe the care team took place? The family comes in with a signed document that contradicts maybe what that verbal advance directive said.
Yeah, this was a question Katrina and I have already gone over. It is, the verbal one is the most recent. It is truly what is the most recent. And so if the verbal is the most recent, then it's the most recent. I mean, a verbal one is as legal as a written one.
Do healthcare providers include social workers and chaplains?
Social chaplains, no. Social workers, because social workers are licensed.
That was it. That was going to be my next question because that also came through right after that discussion as well.
They're not. So do we have any social workers in the room? Because you're not licensed to provide healthcare. You're a licensed clinical social worker. So you're not licensed to provide healthcare. So I would say no. Jeff, or if you're online, if you want to help answer that one.
Figured out. Okay, so even though the previous like advanced directives are no longer legally binding, if there's like unclear language and they're not sure what a patient would want, would it be permissible to like read through those and look at those to help guide decision making, even though those aren't legally binding? But if they're not sure what a patient would want based on the new language.
Sure. So they are all going to be still legal. I mean, that's the where we have all the forms have been grandfathered in. So if you have an old document, it's not that it's not, if as long as it was signed before the first of the year, it's still a legal document. And so you should always look at what patient, I mean, any document that you can have that can help you determine what a patient's values are extraordinarily important. So if you have something that gives you an idea of what the patient would like or what their values were, it definitely carries weight.
So Jeff chimed in. I want to apologize to all the social workers because I feel like this is really variable and ambiguous for them. A social worker would be a provider if he or she is a licensed or certified to provide healthcare. He said it's a tough call.
So I would probably say no. All right, what other questions? do we have?
Okay, so is there provider protection? Is the provider protection valid for verbal advance directives?
Yeah, it sure is. So I know that this is really hard to wrap our ideas around, but a verbal advance directive is as valid as a piece of paper. So it is just as protected, and that you are protected. I'm trying to find that you are still protected. That's why legal has asked that you document as well as you can. You document. Who was in the room? Who, what specifically, what was the circumstances? Just try to, so that you, again, you can replicate the answer, or you can replicate the paper form in just a legal or in just a verbal way.
Okay. So this one I think is, it comes to you get to basically create your own form sometimes, but where in the new form, where does the new form indicate no medicine treatment or DNR? So
it will not indicate no DNR. Those really are, a DNR is not something that I can help anybody fill out. That is a provider that has to be done by a nurse practitioner. Remember, we just went over that list: the nurse practitioner, the PA, or a physician. And so on the advanced directive form, there will not be, has been created, there is not a DNR form. That really does have to be done by either a post form or an out-of-hospital DNR, and only certain people qualify for those. So.
Okay. Is it correct to say that a notary on this form is not required to check for capacity, whereas if the declarant uses the two witnesses, they would be confirming capacity directly on the form?
Well, so I don't want to speak for notaries since I'm not a notary, but I think a notary has the same responsibilities that any of us have who are going to witness. It's just that the notary has a little bit higher level of witness accountability or a witness authority. They get the 2-for-1 deal. But I would think that a notary would be required to do the same, have the same responsibility as being the witness that you and I have as being a witness.
I'm going to ask this for the people in the room and then give the answer that Jeff provided online. So it says, who can act as a representative for the patient in signing? Do they sign their name or the patient's name? Can it be the same person they are appointing as the HCR? And Jeff's response is, if a representative is signs the AD for the patient at the patient's direction, that representative cannot be one of the HCRs and cannot be the notary or one of the witnesses.
Right. So there have to be, in a sense, like 3 witnesses. So it would have to be, so if I am unable to sign for myself and Annie signs for me, then I'm going to have Kelsey be the witness and Matt be the witness. So, and I could not have named Kelsey or Matt or Annie as my healthcare representative. So the basic idea that would be a good thought is to not have a healthcare representative sign as a witness ever.
Guys, these are all fantastic questions.
I know they are, and we've got about 5 more minutes.
5 minutes, and there's still 30 open questions. Are there any limits to the use of IU Health employees signing as witnesses?
There are no limits to IU Health employees signing as witnesses. I encourage and hope that you would be willing to, because what you're witnessing is the fact that a patient has made a statement of preferences. I will also say I'm gonna do an awful job at this, and so Emily can just bury her head. But don't forget that a capacity for a healthcare representative is pretty low bar. It is not the same sort of capacity that you have to be able to do open heart surgery. And so if the patient is consistently able to say, I want my sister to be my healthcare representative, and it makes sense, if it's her sister. If she starts saying that she wants the mailman to be her healthcare representative, then maybe that's not such a wise choice. But maybe the mailman is also her brother. You never know, and she's just a little confused. So don't just remember the fact that it's about consistency. It's about being able to name alternatives. It's about understanding the consequences. And so this is not the same level of capacity as open heart surgery. I just had to throw that in there.
Okay, I'm gonna skip down to the end because this issue of social workers is still kind of lingering. But we had somebody say, wait, just to keep in mind, the issue with provider is we're only talking about the verbal AD consent.
That's right.
With the issue with provider. Social workers can still act as a witness.
Exactly. Yes.
Okay.
So I would say for social workers, make sure you just have the piece of papers in your hand. Have the piece of papers in your hand. And if the patient cannot write down, then you grab another person and then you just become the representative. So yes, the provider is only about a verbal advance directive. It is not at all about witnesses. You don't even need a provider to witness it.
Will the form be available in different languages?
So I do know that the Indiana Safety Coalition Indiana Patient Preferences Coalition. I'm so sorry, Susan. They are working on finding the ability to have it translated. Some of it is around funding and around finding people. Currently, it is only in the English form.
Okay. Do forms apply to non-medical, for example, agency situations?
These really are about healthcare decisions. And so this only really applies to healthcare decision making. This does not apply to sort of any other kind of decision making. I'm getting a nod from Katrina, so I feel all right to say that.
The only other thing that's maybe out of direct provision of healthcare is that it does speak to the ability to apply for benefits for someone to help fund that healthcare. So that's specifically addressed, but it wouldn't really go beyond that.
Super, thank you. That's a really good point.
Okay, I'm trying to look through some of these anonymous questions so that way let me go through a couple more. Does spouse refer to legal spouses only as opposed to life partners, long-term partners, etc.?
It does. Yeah, Indiana does define spouse as a person that you are legally married to. We do not have common law marriage in Indiana either. So it is who you are legally married to.
Okay. For verbal, nope, not gonna answer that. Not gonna ask that one, sorry. I've had experiences where patients have had post forms completed and providers have allowed families to change or go against patient wishes. Example, patient wishes to be DNR, comfort on post, and surrogate decision maker has been allowed to change goals of care. Shouldn't this only be done by an appointed HCR or POA?
Yeah, so I would say that it should never be changed at all if a patient is on the post form of DNR. The patient has stated what their values and preferences are, and the responsibility of a healthcare representative is to honor the patient's preferences and wishes. That's where you need to call your chaplain or your social worker in and help the family deal with the fact that their loved one is dying. And so it is not to be changed, especially if we're going to be reversing it to go to more aggressive care. That's my 2 cents. Palliative care team, is that an okay answer? Oh, I'm getting ahead. Not. We will also say that people's preferences and values, there is a gray area. I will say the patient's preferences and values do change upon as their healthcare condition changes, and maybe they're in the hospital for something that can be cured easily.
Son was healthcare representative, and we had completed post form and outpatient. There'd been some time in between that post form and the admission into the hospital, and he had sworn up and down that he had had conversations with the patient, and the preferences had changed. And so the patient finally was able to answer some of those questions himself, and indeed they had changed. So that's where the gray area lies. If the healthcare representative is representing that patient in the best of their ability and knowledge with conversations with family, or with that patient, I can see where it could be lifted and changed. So.
Thank you so much for those stories. I mean, that's it. That's always the challenge with any of it. I just know that a lot of times patients state what their values and their preferences are, and then that gets reversed. So we have to be very careful about, and people do change their mind. They do. Right. Right. The post forms, what has just been said is that sometimes the post forms are not honored initially. And so how do we make sure that those post forms are honored initially? So I know that there are tons more questions out there. I will answer as many as I can. Oh, Annie, you have your.
Well, so yes, thank you. I think we're going to close the questions for right now. I know some of you still have lots of questions online, and we will make sure that Robyn gets those questions. There were questions more about the capacity assessment and a few other questions as well. So there's some great questions.
I would say the questions about capacity assessment, if you want to go back on our website and look at the great lecture that was done by Dr. Emily Holmes at our last lecture, or our last, is that lecture online, Annie? There are many options for you to be able to find out how to do a capacity assessment that I'm not going to be able to answer because I don't feel qualified to do that. And so we will find those resources for you and help you get some of those resources to be able to figure out a capacity assessment. Also, if there are teams that would like me to come and help with this, I'm very willing to do that. I know that I am meeting with a couple of other teams that I already have set up appointments with later in this month. Also, if you are at an outside hospital, you have people in your hospital that are looking at this. Maybe it's your legal team or your risk team, or in Fort Wayne, you already have an advance directive team. And so please reach out to them if you have any questions about your own hospital setting.
And Jeff, thank you so much for helping answer questions. I know you were able to answer a lot that we didn't get to.
So, all right. We appreciate your time. Thank you so much for being here.